wonderful as it's been, has really brought up a tension that I live with and I think really often try to ignore and just sort of push down. But that's a tension for me about how much energy do I have to do constitutional law differently, but feeling a really heavy obligation to push for change and use my privilege. And so it's been really emotional. And I also have a kid that's been screaming for an hour or two every night, so I get no sleep. But I am really grateful to be here, and I'm really grateful for my parents coming over today to watch my little one. And if she awakes from nap, she may come downstairs and start screaming. And her new favorite thing is to go, Mom, 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 Mom. So, but I think we'll make it through my presentation at least. And I'm really grateful to see so many friends and colleagues here today, some colleagues from U of M. And I want to thank all the previous speakers and to David for organizing this. This has really been wonderful. And I just need to apologize that he had to send me at least 2 emails every time he asked for something. And I'm really sorry. I'm so terrible. But I'm happy to be here. And I just want to say that I think I saw online this morning that Mr. Sparrow passed away. Didn't get a chance to fully read the article, but if that is true, I'd really like to acknowledge him and thank him and his family for the sacrifice he made in putting himself before the Canadian courts and all that he was able to do. So with that introduction, I think I'm really excited that this forum on constitutional laws, including some consideration of where the UN Declaration fits in. And I'm really happy about this in particular because it was only a few years ago that I wrote a piece on implementing the UN Declaration, and it was rejected by a major law journal here in Canada because I didn't prove that international law applied. And I mean, I had cited the Supreme Court of Canada cases, but it really showed to me that there was a perspective that international law had no relevance in trying to understand Indigenous peoples and Indigenous peoples' rights. So really thinking today, boy, if we come far now where we have a national forum happening, and this is one of the few topics. So today I want to try to do a couple of things in the few minutes that I have. And I want to warn people that I'm going to ask you questions, and I'm hoping that people will perhaps use the chat function and give some answers. So if you haven't already done so, maybe open up the chat function. But I want to think about what do students need to be able to critically engage with Section 35 jurisprudence. And you can see within that is an assumption that we need to critically engage with it. I also want to think about what do professors need to help students engage in this process. And then I want to think about what does the UN Declaration bring to the table. So my first question to all of you is, why was Section 35 included in the Constitution? And I know those are big questions and not easy to quickly chat out, but I think if we're going to start to question Section 35, thinking through why was it included? My second question, so people can start queuing up answers, is from Indigenous people's perspective. Why was there so much effort into bringing recognition of Aboriginal treaty rights into the Constitution? I'm hoping we have some alert people and really fast typers that someone will start providing us some answers here. Because I don't want to do all the talking, though. Maybe that's why they're paying me the big bucks. I'm going to wait and give people 1 more minute to see what we come up with. People have to have ideas. You're all incredibly learned, and it's a little intimidating. Would be the other reason why I'm stressed, and I wasn't going to admit that, but perhaps I will. Oh, I'm a little disheartened. I don't know if people don't have answers, or is it too late on the Friday to have nation-to-nation governance? Yeah. To change the course of constitutional law in Canada. I agree with both of those. Any other thoughts? Yes, Naomi, I am a teacher. I want to put everyone to feel in class. Because of Indigenous lobbying, Constitutional Express, yeah. And it didn't just happen, right? I think it's really important to always remember that Indigenous peoples fought hard and sacrificed a lot. The historical imposition of an external government caused major inequities, and those inequities inside of Indigenous peoples' nations. Thanks, Jamie. Yes. They needed to resolve some of the issues in order to move forward. Yeah. The reason that I'm asking those questions for many of the premiers to freeze Indigenous rights, to legitimize Canada's sovereignty over the entire territory, and recognizing that, yeah, I think, John, that many Indigenous peoples were resisting this what could be viewed as a domestication of constitutional rights. And so for me, the reason why I wanted to answer these questions and get us sort of thinking through and trying to be really active in this is because we need to remember that there are always perspectives. And I think we've been talking about that. And so one of the first things I think about when, what do students need to know to be able to start critically engaging it? I think understanding the why is this there. And in order to understand why Section 35 exists, I think thinking, why did Indigenous peoples bring it forward? What was the resistance they experienced? But also, I've come to realize after 10 or 12 years that I've been teaching constitutional law, is really recognizing that students come to this point in constitutional law with very different backgrounds and understanding. And so realizing, for me at least, I couldn't start teaching Section 35. That's not where I could start. I couldn't start critically engaging with the Section 35 cases because the students didn't have anything to use to critically engage, or most students, some definitely did. So I think for me, what do students need to start engaging in at least a critical process? They need some sort of grounding, some sort of basis. And I was really interested in what Jeff was saying this morning about how students were making comparison to other areas of law. And I find that definitely when I teach treaties, that many people are relational thinkers and want to connect new information to existing or to other information, right? And so what happens when they're learning this new information and have nothing to connect it to, right? So then they start making these false associations perhaps, or associations that should at least be somewhat attenuated. And so when I start to think about Section 35 and teaching constitutional law, I really have been grateful that my colleagues at U of M, when I started, already had Aboriginal and treaty rights as a graded component of first-year constitutional law. And I wanted to throw that idea out there because the idea is that it's not equally weighted, but I think in my course it's 35, maybe 30% of their 25 to 30% of their final grade. And so when we teach the information, it's about 4 or 5 weeks. So it has significant space and it is a graded component. So I think the idea is signaling to the students that it is a core part of the course and not an add-in, but it really has that space. But I think there's always those sort of challenges to keep thinking through on what do the students need to be able to do this. And one of the things that I've come to realize that what students need are professors who have an ability to critically engage and understand the Section 35 jurisprudence. And so that's where I'm so grateful that David created this forum today, because I think we all have so much to learn in thinking through how to do this work. And so finding ways and resources to help one another to have the tools and the knowledge we need to start critically engaging is important. But I only have a minute or two left, and so I wanted to bring together, from my perspective, what does the UN Declaration bring to the conversation? And if I had more time, I might sort of, get us to start articulating what are some of the critical and problematic aspects of Section 35, but I think many people are already there. What I thought perhaps that I could contribute to people's learning on how to start engaging this critical process is, what does the UN Declaration bring? And for me, I think there's maybe, I sort of thought of 5 at least today, aspects that the UN Declaration really brings to the conversation. And that's the UN Declaration focuses on the peoples aspect and recognizing rights of peoples. So I think Section 35 is far too focused on this understanding of Indigenous and protecting whatever stereotypical ideas we have as Indigenous. I think the UN Declaration grounds the rights in peoples, and yes, they are Indigenous peoples, but they're peoples. And so Articles 1 and 2 start with equality and non-discrimination. Lots of people like to jump to Article 3 on self-determination, but I think it's really important that the UN Declaration recognizes the rights of peoples on the basis of equality, of course, substantive equality and non-discrimination. The UN Declaration in its preamble explicitly states that its goal is to address the historic injustices of colonization, including the impacts of the removal of Indigenous peoples from their lands. There's also, I think, a really important recognition, and this is one of the challenges I see with the discussions of Section 35, is that people somehow continue to think that recognizing rights is undermining Canada or going to tear us apart. But I think the UN Declaration is really clear when the UN says they are convinced that the recognition of rights of Indigenous peoples actually will enhance harmonious and cooperative relations and can help us move past a colonial situation where Canada has control over Indigenous peoples to rejigging the relationship to be based on principles of justice, democracy, respect for human rights, non-discrimination, and good faith. I think the UN Declaration is really useful because it grounds Indigenous peoples' rights, the framework of the understanding of within the human rights framework, it's grounding Indigenous peoples' rights in their own customs, laws, and traditions. And there's many references throughout the Declaration to Indigenous peoples' own laws, customs, and traditions. So how do you understand the right to land? How do you understand the right to participation? You have to turn to the specific Indigenous peoples' specific laws, and that's what we're protecting. The other aspect that I was starting to think about that the UN Declaration does is it really shifts who gets to frame the rights. So I think far too often through the Section 35 jurisprudence, it has been the court that is framing the rights. In so many cases, you see the court say, the claimant asserted this right, but we're going to talk about it in this way. And I think one of the key aspects of the UN Declaration, by grounding the rights in Indigenous people's own laws, it reminds us that Indigenous peoples are the ones who are going to frame the understanding of the rights, and that the role of Canadian state is to create space for that recognition in the state's legal systems. And I think that can also be an important contribution. So I can't remember how long we had to talk, but maybe I'll just sort of leave it there and pass it over to John, and then leave it over for open for questions, if that works.
Sure, Brenda. And that'll give us a little more time for a conversation. Let me introduce John, who needs no introduction. Old friend of mine, former colleague at University of Toronto, but also a Kitsarak Law School, memorably in Iqaluit. Many of you, well, of course, John's Canada Research Chair in Indigenous Law at University of Victoria Law School. Many of you are familiar with his path-breaking books that I think has, in and of itself, made University of Toronto Press profitable. And they include, of course, Recovering Canada, Canada's Indigenous Constitution, Drawing Out Law, Freedom and Indigenous Constitutionalism. These are all sole-authored books, and most recently, Laws Indigenous Ethics. John is a Anishinaabe Ojibwe, a member of the Chippewa of the Nawash First Nation in Ontario. And so we get to see him in Southern Ontario ever so often, which is a blessing. So John, it's over to you. Thanks.
Miigwech, Neji, Miigwech, Ginoa. Thank you, everyone, for being here. It's wonderful to be with friends and to just enjoy listening to people I've learned a lot from over the years, and then see other names and faces and remember what I've learned from you and the good experiences that we've had for those of us that have crossed paths. I'm speaking to you today from the Lekwungen speaking people's territory, the Esquimalt and Songhees, and also the Wisanich. And it's beautiful to be able to live here in this part of the world as well. David asked me to talk about rights today, and I'm going to go on a whirlwind very quickly because, you know, I'm teaching this new course. It's in its third iteration now, a trans-systemic course in constitutional law that teaches Anishinaabe law alongside Canadian law. And so if it's possible, I want to just show you the course review from the first and second terms, and then maybe a couple of the exams that I set, and then just a little bit about rights themselves along the way too. So I'm going to share the screen here and talk incredibly quickly to be able to go through some of this material. So I guess I'll start with this. Basil Johnson is an elder I learned a lot from at home at Nayashiwinigming at Cape Croker, which is about 3 hours north of Toronto. And I asked him about law, and he would always give me all sorts of different directions. And he talked about the concept of rights as being de bene ozawin. And he said that's a right to make a living, which includes work and clothing and shelter and tools and medicine and education. He says the word actually means as far as or according to your needs. So then he gave an example. If you have children, you have more need because you're helping them. And the word so that's one part of it. But he's always trying to correlate words together and not just get me stuck on one story, but show the relationship between concepts. And he also said that there's this idea of mitidaduin, which is sharing. And he says it's not sharing like everyone gets everything equally, but according to their needs. And this sharing is also dependent on people's energy, which means that a person should earn a share. There needs to be a contribution in sharing. And this is my little note there in the bracket. And then he said, your family used to go to the Grey Highlands and spend the winter in the cedar bush there. And he talked about my family as he did this. And that's when they would engage and live this way, de bene ozawin and mititdaduin. And so when I started thinking about rights, I was thinking about sharing and the limits on sharing. And you know, there's some correlation and analogies that we might draw to the way rights are framed in terms of the right itself and then the limitations on that right under Section 1. But that's not immediately where I went to, because so much of what he was talking about was the understanding that we are constituted and constituting in relationship to the earth. The word for constitution in Anishinaabemowin is a nakonage, which is a verb. And so constituting, constituted is a practice. Constitutionalism is not something that's categorized, it's something that's conjugated. And so if you're living in a verb-based world, as Algonquian languages are, and you're conjugating constitutionalism, then you're thinking about the practice and the relationality of constitutionalism. And then I contrast that with other ways that you often get the framing of these laws. Here's a statement that Ben Berger gave to me about rights. Our rights, which art in charters, hallowed be thy claims. Thy kingdom come, thy will be done on earth as is in theory. You know, this idea of rights can be very godlike. It can take us into places that are overarching as an epistemology and way of being able to relate to the world around us. And so when I talk about rights in my class, I want to reject rights, and I do so quite strongly. And then I also want to embrace rights, and I also try to do so quite strongly. And you might think, well, how can you do both of those things at the same time? And my answer is, it depends. It depends on who you're talking to and the purposes for which you pick these things up. And so that's sort of where a lot of this comes from. And thinking about constitutionalizing, constituted as a verb, and recognizing the trickster that's in this field as we do things that are simultaneously selfish and selfless and harmful and kind and charming and quite devious. I don't think there's any way to get away from those kinds of cleavages that we have in our human interactions. They might be differently formulated. Rights is not a universal term. It's a very particular construct for this time and place and era. People weren't necessarily talking about this 500 years ago, at least in the way we're doing. The Greeks weren't talking about it. The Romans weren't talking about it in the same way. It's not biblical language. It's not really Quranic language. That's not really the way Anishinaabe people talk about it. So to talk about the universal nature of human rights is to, first of all, overstate the situation, and then just secondly, not to realize the context that we find ourselves in. So now let me take you to just a little bit of the framing for the course. This is my first semester's review. I try to talk about what law is as a verb, and the way we might have different ways of patterning orientations to criteria for making decisions. I go outside a lot when I teach. Often I'm in the bush behind the law school here, and I'm telling creation stories. We're looking at spiders and ants and deer and turtles. I'm singing songs. We're doing pipe or tobacco work. So there are a lot of things that are going on in the unwritten sharing of Anishinaabe law, as well as being able to share about written constitutionalism of Anishinaabe law. Many sources of Anishinaabe constitutionalism. That is, you can't just look to one place to try to understand what's going on in this world. Like I said, we do a lot of work with fire and water and rocks, plants, insects, and animals. And if you break down the etymology of each of these words, they contain orientations to the things that are in the world. So we see our law professors as being the plants and the animals and the rocks and the insects. And so we try to draw analogies from behaviors that we see there, or we distinguish as the case might be. Talk about the language a lot, as I mentioned, and as a part of this idea of Chinook and Agavan, I borrow a lot from Aaron Mill's work of rooted constitutionalism, making sure that people understand that constitutionalism comes from a life world, a set of ways of being in the world, a set of practices that have to be understood on their own terms. And there's lots of stories that I try to tell around that rootedness. I talk a lot about the 7 grandmother and grandfather teachings, and I'll get to that in a moment, but those are appearing quite strongly in written Anishinaabe constitutional documents and in tribal court decisions in the United States, because the Anishinaabe people are in Ontario and Quebec and Manitoba and Saskatchewan and Michigan and Wisconsin and Minnesota. And so it's a tradition that we can draw back and forth across the borders, as it's practiced differently a little bit in the US context. And so these 7 ancestral teachings are picked up differently there. More about the relationality of Anishinaabe law, which I help to get people to go through. And then just tons of stories about plants. And last year we assigned braiding sweetgrass as one of the readings as a part of the course. And then we talk about many written constitutions, and I'll just try to go here second to some of those written constitutions. Here you've got, well, first of all, UNDRIP talks about Indigenous peoples having the right to self-determination as and other things, as Brenda was talking about a moment ago. But I also try to make the point that Indigenous peoples also have the entitlement, if they're going to adopt UNDRIP, to expect their governments to at least analogize some of these protections. They don't have to be in rights terms. I'm drawing on the work of David Millward here and his work on the charter as it applies to criminal law. But what are our ways of making sure that people can express their spiritual beliefs and speak and associate and have minobamatsuin and what's the property analogies, etc. So here's the Minnesota Chippewa tribe. They have a federalism structure within their community. They have an overarching set of authorities, and then there are 7 communities that each have their own provincial-like jurisdictions. The Weequamecoong Constitution talks about things that are fairly not original, if you would look at this from that fire and plants and water base, but they've also chosen to take up their ideas in this fashion as well. Little River, Odawa Band, the White Earth Nation, preamble here, successors of a great tradition of continental liberty, a native constitution of families, totemic associations. The Anishinaabe create stories of natural reason, of courage, loyalty, humor, spiritual inspiration, survivance. It goes on in that vein. The Nipissing First Nation is quite interesting. I hope I can pull up their work here. Maybe not. Oh, those are the exams. Oh, here we go. They've got some statement of rights and freedoms, but that they also have statements of values and beliefs about well-being and unity and fair treatment and harvesting of gifts, and then core values of, again, family unity, religion and spirituality, and relationship to natural resources. Anyways, the point I'm making here, and you can take into other nations too, that there are rights, there are ways that Indigenous communities pick up rights, including Anishinaabe communities, and just here's the example of the Haida Nation. So we go through those things, and I go through, there's something called the Anishinaabe Governance Nation Agreement, which is a group that's sort of with the Union of Ontario Indians that has an overarching structure again in Ontario. So here's that sort of the national agreement as it is, and then there's more detail on that. And then there's local communities that enact laws and constitutions under that agreement. This is controversial. People are voting and ratifying on this. Some people have chosen not to ratify it. Other nations have ratified this way of proceeding. But what's running alongside of this in Gordon Wabadance is advancing the clan-based system of government at the same time. And I talk to my students a lot about that. Here's the legislation, here's the Weequamecoong. And then I take this into the trans-systemic mode. So how does all this relate to Canadian law? So we look at how Indigenous peoples have treaties between themselves, but we look at how we had treaties with the natural world before we had treaties between ourselves, say between the Haudenosaunee and the Anishinaabe. We had treaties with the deer, we had treaties with the bear, treaties with the bear gave us wampum. There's just so many things to pick up. And then we've talked a little bit about the Turo wampum and Treaty of Niagara, and then there's other treaties that we can cover in that. We also talk about imperial constitutionalism or Canada's colonial constitution, and these ideas that are running around in the jurisprudence of discovery, terra nullius, occupation, adverse possession, conquest. And then we start to look at the cases and how the cases pick up different strands of this and are just completely inconsistent and have moments of possibility and great moments of harm, as Naomi was talking about in her work. And this is probably now a little bit more familiar for those that are working through the federalism pieces of their courses and the Aboriginal rights pieces. Here's the second semester. Here's the different organizations, right? On the one side is the book that I work with Patrick Macklem and others here on this call along. And then there's this other side of thinking through reasoning with Anishinaabe or organizing Anishinaabe constitutionalism. And again, lots of stories, lots of song, lots of outside time, lots of observation as a part of that. The Restool case is a case dealing with the Robinson-Huron treaties, the Annuities Clause, and Justice Hennessy there was asked to try to take the perspective of Anishinaabe law and understanding those treaty annuities. And so there's live stream information that the students are able to access. And we talk about the way the judge deals with Anishinaabe law, the way that elders are introducing that law to her, the way the wampums are read, the way the pipe ceremonies are done. And then the other book I used was Honor Mother Earth. It's a book that my friend again, Basil Johnson wrote. He wrote 25 books, lots of stories about insects and again, plants, animals that I just keep moving along. And again, this idea, there's a lot of sharing and there's a lot of limitations on sharing. And then that gives me an opportunity to go into Oak's kinds of analysis. You know, what's sharing that we do, that we have across our community, and where are the limitations of those kinds of things. And you know, we're fortunate in Section 35 to have a lot of cases dealing with Indigenous peoples here, Corbier, Lovelace, Cap, and Kakawistahau, that I pick up some of those concepts with, and I tell them stories about Mandamin. The last chapter in Canada's Indigenous Constitution is how we got corn as Anishinaabe people, which gives me an opportunity to think through some of these things. Look at Indigenous women and gender and property on reserve, and look at the Indian Act history around status and discrimination and marrying out and marrying in. Look at issues of children and communities, and we talk a lot about Anishinaabe law related to children in that section. We look particularly at the child caring case. Patricia Cochran, Professor Cochran comes into my class at a certain point and makes a presentation about that. We go through Métis rights. You can get the point, right? And so I look at tribal court cases, sometimes Anishinaabe cases, but sometimes they're from other tribal courts from across the United States. Here's an interesting case dealing with a Section 7 type right, Bailey versus Grand Traverse, that talks about the procedural due process as opposed to the substantive due process. You know, that debate was there at the time of Morgenthaler and how we've kind of moved past that with the Carter case, but it keeps rearing itself. And there's Anishinaabe jurisprudence on that point from tribal courts. And then we talk about what is Anishinaabe life, liberty, and security. B'madazawin, Bain Indizawin, Ganawayne Jagawin, and we talk a lot about sky teachings and caring for our elders. And I'm just about finished here. There's exams that I can set about tribal court jurisdiction and how that might be supported or not under Section 9124 of the Constitution, or Section 35, or UNDRIP, or Anishinaabe legal traditions. This is the one I set this past April, was a COVID issue, and there was a community that put a lockdown on their community, and someone wanted to come home back into the community. And the question was that a limitation of their religious rights because they were ceremonialists? Was it a limitation on their life, liberty, and security because they couldn't actually be amongst their people? Were there equality issues that were found in that? But also the students were talking about Mandamin and the insects and the creation stories. And so they wouldn't just frame things up in Section 15, 7, or 2. They would also frame it up in this whole other life world rooted way of constitutionalism as well. Here's a federalism question with the Rama bylaw around cannabis, and who has the right to can the Chippewa of the Rama pass a bylaw that would oust provincial jurisdiction, and how does that relate to the federal act? And so you can see there's a lot of pieces that I try to pick up through the year with this trans-systemic course. It's a wonderful thing to be with these students. It really challenges me. I think it challenges them. And it's going to be even more challenging now doing this online because we can't go outside in the same way. But perhaps that gives you a sense of just what we're trying to do here as students get a JID and a JD. Because not only do they have my trans-systemic constitutional law course, they have one in Gitsan law and land relations, one in pre-law and ideas of voluntary obligations, and then they have Hulkaminam law and involuntary obligations or tort-like things. And anyways, it goes on and on and on. And so this is one piece of many things that we do in our law school. And then students have 2 field schools that they have to do for entire semesters before they graduate, working in community as well. So I'll stop there. I know I went really quickly, but to miigwech bizinduweg you, how, thank you. And I look forward to any questions, comments, concerns, critiques. It's just great to be with everyone.
Sorry, I had to unmute myself. Thank you very much, John, and thank you very much, Brenda. So we have about 20 minutes to talk. So I'm looking around. I don't see any hands up, but if anybody wants to begin, please begin speaking.
Hi, it's Jenny Nadelsky. Hi, John. Nice to see you. I wanted to ask you a question, which I think of as following from Aaron's comments earlier. I wonder, when your students are writing exams and moving back and forth between these different traditions, do they comment on the ways in which sometimes those different traditions are building on very different assumptions about what human beings are, how they're related to the natural world? Is that part of what they're doing? And they draw on both, but are they talking about different foundations of this different systems?
They definitely are. And some of them are quite strong in choosing one over the other, or rejecting one even, and choosing the other. Others try to work a synthesis or work syncretically. And it's all allowed. All of those ways of approaching it are totally on in my class. And last year, we had that Wet'suwet'en blockade here in British Columbia. And my students were on the steps of the legislature for about 3 weeks. And they were down there doing that work as a part of trying to understand Anishinaabe and Indigenous law more generally. And so, yes, they do that self-reflection. Some of them are more explicit about it. Others are more implicit in the way they work through it. And it's certainly in the classroom, it's one of the dominant themes.
Thanks.
Okay. Someone else? No? Please speak up.
While people are thinking, let me just add, the last few years we've done Anishinaabe law camps with the University of Toronto law students coming up to the community, and Osgoode Hall law students, McGill law students, and of course we're not able to do that this year, but I find that a very valuable part of helping students get oriented in a way that's not the classroom. We've done the same thing with Windsor at Walpole Island, and with Western Law School at Chippewa of the Thames with Michael Coyle and his colleagues. And we do that out here at UVic, although it's not an Anishinaabe law camp, obviously. But there's something about that kind of orientation that Darcy was leading us through before. And about a year and a half ago, I had a chance to teach a class called Anishinaabe Law in the City. And so there I was in the University of Toronto, and we were at Queen's Park, and then the ravine there, Tattle Creek, and then over to the anthropology department, into the museum, over to the Massey College where the wampum belts are. You can teach courses outside, and even in a place like Toronto, you don't have to go to a far distant reserve. Anishinaabe law is right there in the Queen's Park environment.
John, Patrick, the virtues that are, this might be an odd question, but I think it does have a bit of a connection to pedagogy. The virtues that are represented by grandparents, the 7 great grandparents, etc., is really striking. And I'm curious if vices have similar ancestral representations and stories attached to them, things like jealousy or etc. Envy.
Yeah, that's a great question, Patrick. And I think that's right. It's not just the case that love has one meaning alone. As I tried to talk about in my book, there's many different ways that Anishinaabe people can approach love. And some people approach love in ways that are paternalistic and controlling, and likewise with truth or humility. So within the concept itself, there's many different meanings, many orientations to that. And then yes, you can go to the other polarity, and you can pull out ideas of jealousy and hate and lies. In fact, I've sometimes entertained the notion that that might be a good subsequent book, is to talk through Canadian law in that light, as well as Anishinaabe law in that light, because we have our own set of pathologies and ways that we harm one another before Europeans arrived, and certainly harm one another today. And some of that's, a lot of it is in relationship to colonialism, but there's just other things that we do as humans. And so that would be great future food for thought. And in some of the tribal court judgments in the United States that Matt Fletcher writes, who's a professor of law at Michigan State University, he talks a little bit about what he calls bullshit law, law that is often built on lies and hate and manipulation, pride, etc. So thanks for the question. I think there's much more to talk about down that path.
I noticed that Jamie asked a question in text, and I have no answer, and I don't know if anyone else does, but you know, so many wonderful ideas today on what needs to be incorporated and needs to be done. But I think, how do we fit these in our courses, and not in that sort of, you know, ideological way, but like practically, how do you create space? And I like that she phrased it, you know, what readings would be cut from your textbook, John? Right? And I think that's a real question, and I struggle with that. You know, I can envision a constitutional law class where I do things really differently, but in practice, I don't really do that, because, you know, this year I had a 40-minute introductory class with students to sort of get them situated, right? And so how do you sort of, yeah.
So this is one of the benefits of teaching transsystemically, is that we're supposed to be focused on that point. And I have 4 hours in the first semester and 4 hours in the second semester to be able to do this kind of work, because we move some of the so-called first year courses into second year to create that space. But I do actually use my casebook to do this. So you can teach federalism, rights, and Section 35(1) through the work that the book that Patrick and I and others are editing. But you can also teach constitutional law using that Aboriginal legal issues, cases, and materials that Len and I work through as well. And yeah, so you just have to then choose something that's representative, rather than just being, you know, I'm going to cover the entire field.
Well, and I think,
Brenda, are you using UNDRIP in your own constitutional law course?
yeah, I do, but I don't, I mean, but it's part of that sort of introduction and critical lens, right? And you can sort of bring it in, but the semester is so packed. And I think, you know, while not completely transformative, maybe there is value to that sprinkling in and slowly adding in more perspectives and trying to mainstream and bring it throughout, and always reminding ourselves of then, you know, when we're making tough decisions of what needs to be cut to make this space, that we give the equal value to the Indigenous laws and perspectives and criticisms, because it's not always the case, right? We think, oh, well, we have to teach these aspects of federalism, and I can only do this if I have time, right? And what would it mean then to think, if they're on equal footing, that we then have to cut out mainstream federalism, Canadian federalism, 91, 92 federalism, in order to make sure we have the space? And I think that could, for some, be almost a radical idea, right? That it's okay if I don't teach the criminal law power. Not saying I will, Karen, not saying, but right, that is that legitimate then to say, I'm going to teach 91, 24 in federalism and talk about Indigenous jurisdiction, and I'm not going to talk about POG, right? Like these sort of ideas of if we were to make that choice is, what does that mean? I don't know. I really appreciate the question, Jay, because I definitely struggle with this and have no clear answers.
I just finished a book about teaching by a fellow named Peter Lindsay. And his main thesis is that doesn't make a difference, makes no difference what we cover. It's about making students excited about learning outside the classroom. And that's our job. So it really makes little difference what we cover, that's not really what we should be preoccupied with, but exciting students, right, to carry on this lifelong journey of learning. And I was kind of inspired by that. But I, like you, Brenda, I don't see how I can just dispense with all these things I feel obliged I have to convey to students. Maybe there's a way to do it more, if I can use the word, efficiently, so that we can make space for the other things, right, that we think are more important, right, than various of the discrete federalism or even rights questions that we address.
There's a woman who's writing in the United States at the University of Pennsylvania. Her name is Maggie Blackhawk, and she's asking us to question the canon of constitutional law, at least in the United States. And I think we need to do this similar work here. What is the canon? Why do we think we need to cover certain things always in the same way? Because I agree with you, David, at the end of the day, we're not just teaching materials, we're teaching people. And so if we can keep our focus on the context of where our students are coming from, we could even find ourselves improvising along the way in our syllabus.
Can I ask a question? And I don't think it's been addressed yet, and it's sort of, for me, the elephant in the room when we're talking about any law course, is evaluation and grading. And I feel like everything that's been raised in this last part of the discussion is essential. And then we get to this really rigid with law faculties that I'd love to hear any perspectives that kind of open these decolonial contexts.
Amy, you were breaking up quite a bit, but you were asking about grading. It really does determine how we go about doing this. I think you're quite right. So is it a question about rethinking how we grade our students, evaluate their performance?
I think that's right. And I've been fairly conventional with my evaluations, even though I think other parts of the course are trying to push the envelope. But that's on purpose. There are other parts of our curriculum with our field schools. Students right now are doing a Salish Law and Language course with Sarah Morales that have different forms of evaluation. I think if you, across the entire, we have 4 years because we've got 2 degrees that students get. If there are different forms of evaluation across the 4 years, that's appropriate. But for my class, I want them to be able to generate something that could either go to a council or a tribal court judge or a policymaker, and that lends itself to the exams that I offer. But in other cases, like I remember when I taught the intensive course at Osgood, students just got a written evaluation that got affixed permanently to their transcript that outlined what they did and how they related to what they were assigned to do. So there are great ways of thinking about other ways of evaluation too.
And I think, Emma, your point goes to, I think the idea that I was thinking about, one of the things we do at U of M is grade Aboriginal and treaty rights, and it's a paper to give people space to engage with the ideas. And I think there's benefit, as I was saying, to creating that, you know, the idea that this is real content, it's, you know, on par with everything else, and it's an integral part of what you need to know in constitutional law. But I do struggle with whether or not that idea works by creating essays and assignments, and whether or not there may be other ways to do this. And I don't even think just assignments, but, you know, yeah, it's something that I struggle with all the time, is what can we do to sort of help the students learn this material, and what are sort of the ways that, or what are the benefits and drawbacks of having students write papers, right? Then, you know, if as soon as you give out their paper questions, are they just sort of picking that out and gonna lead through other things? And I think that's a challenge. Yet again, no answer from this panelist.
Can I ask a question about something else, but related to teaching? For the benefit of those of us who aren't Indigenous, can you say something, either of you or both of you, about the permissions or the protocols that are necessary or appropriate for sharing Indigenous teachings or stories, for example, in the classroom, or for that matter, in writing?
Yes, it depends. Because each way of understanding or delivering or speaking about or passing along that material will have some specificity attached to it. And so, you know, for some people, you need to put down tobacco. For other people, you need to hear the story maybe 5 times. For other people, you need to specifically be gifted that in a transfer ceremony. For other instances, it's just published, and the author says, go ahead. Because like Jeff Hewitt talked about, the work that Sylvia McAdam did went through ceremony. And so because there's so many different specificities, or it depends, then what that does is it requires us to develop relationships. So I'm not Indigenous to the West Coast, and I have no rights or can presume to have any thing to say about Salish law unless I develop relationships with Robert Clifford and Sarah Morales and, you know, the other folks and friends and people that I've gotten to know through the years. And so for me, what lies underneath this all as a non-Indigenous person that is not Salish on the West Coast here, I need to develop those relationships to understand when I can talk about the transformer figures or the creation story. And there are things I can do to do that. And I'm grateful for people that help me through that. And then sometimes I'll do it wrong, and I'll have to be appropriately corrected. And that's hard. And my face goes red, and I sleep terribly, and I feel bad for weeks or months. And like it's painful to learn in a context at times. But in other times, the people are so hospitable. It's so fantastic. They're just so grateful and appreciative. And I walk on cloud 9 for weeks and weeks and weeks. So it's not just all one thing or the other thing. Kent McNeil and I are writing a book that we're the editors of, that has to do with this question in part, which is about appropriation, and when is it appropriate or not to be able to speak about issues that might not be from your own culture, community, legal background. And we've learned a lot through that, and we're going to keep learning more. It's Sarah Morales and I often thought we wanted to write a book called Uncomfortable, because that's often what we feel. And a whole book, I think, of just that set of narratives would teach us a lot too. But it's not the only narrative. There's a lot of comfort and joy and peace and love. I mean, there's a lot of good things that go along with the bad things.
It's Patrick. I have a related question, which is, in your work with Kent McNeil, do you cover the topic of non-Indigenous folks writing fiction that involve Indigenous stories and Indigenous characters?
So I see Kent McNeil on the line here, and I just like to give him a chance to speak for a second. The question was, Kent, do you anything in our book about non-Indigenous people's permission to tell stories that are Indigenous stories, that sort of thing?
Maybe not directly, but the book's composed of chapters by Indigenous and non-Indigenous authors, and we ask people to not write necessarily academic pieces, but more about their experience and just the way they might have addressed some of these issues and so on. So there's quite a range there, actually, and I've been quite amazed by what people have been willing to share in their chapters, because many of them are quite personal. And people are talking about, what they feel they have permission to do in some ways, what they don't. Yeah, I think this is a very important topic, and it's something we all struggle with. Maybe non-Indigenous scholars more than Indigenous, but I think, it crosses over, as John was saying. He's not Indigenous to Salish culture and society. Yeah, John, you probably got some to add to that.
No, I just really appreciate what you said there, Kent, because it is just so specific to the circumstances, as I was trying to say when I was answering Carrie. I'm sure that some of my colleagues would disagree with me, but there are some universals, and I'm not saying that there aren't. Myself, I've not identified them. I think in some cases it's appropriate for non-Indigenous peoples to write about fiction that has Indigenous elements to it. And in other cases, it's totally off and inappropriate and wrong and harmful. And your readers are going to take that differently, right? I just think you have to be solid as a writer, that you've got those relationships that allow you to work through that issue, even if another 50 people are going to disagree with you on the other side. And of course, you want to take account of that disagreement and consider whether or not the permissions or the relationships you have really should cause you to not or to write about it. I just think it's a question that is too contextual to really lend itself to a wider answer, although we always have to pay attention to the power dynamics and the imbalance there, and but how that works out, I can't say universally what the answer to that question is. But the essays in this book are trying to grapple with that, and we asked our authors to write kind of an Atlantic style or New Yorker style. We're not trying to be presumptuous. We're just trying to get people to write more directly about what the issue is.
Okay, folks, it's just after 4. I don't know whether there are any more questions or interventions. I'm happy to leave the Zoom meeting ongoing, turn off the recording in a moment. So let me thank Brenda and John for their presentations and their thoughts. It was very valuable, and I'm glad that we were thinking practically, because that's what I was hoping we might do more of today. So let me conclude. Let me conclude by thanking the dog, and also, of course, everyone who spoke today and all of the participants on Zoom. So when I envisaged this workshop, I was inspired by Thomas King's suggestion, this is in his Massey lectures, that you'll never believe what happened next is a great way to start a story. And I think if we think about constitutional law in those terms, that is, you wouldn't believe what happened next, might be a way of kind of decentering the dominant narrative and opening up space for alternative ways of thinking about how we govern ourselves and how we choose to govern others. So really, it's about reimagining our course. This is just the beginning of that conversation, it seems to me, at least from a non-Indigenous perspective, that is work that needs to be ongoing. So I think of this as, you know, as a non-Indigenous person, as baby steps. I'm learning, expanding my knowledge base. And I hope that we can continue to do this in person, even. Once we're able to travel and meet together. So as I said, I invited folks to earlier. I said earlier that I'm inviting folks to send me their syllabi, and I'm going to try and create space on the Decolonization website for people to have access to those. And the conversation will continue. So thanks again to everyone.